Hello, everyone, and welcome to today's live webinar brought to you by immigrationquestion.com, your trusted source for immigration news, expert legal insights, and real time conversations with experienced immigration attorneys. My name is Nikita Bahadur, and I'll be your host for today's session. Pathways to Employment in the United States, Understanding Non Immigrant Work Visas for Investors, Entrepreneurs, and Professionals. For investors, entrepreneurs, and professionals, the United States offers incredible opportunities to grow, work, and build a future. But before you can get started, you need the correct visa, and navigating the options can be overwhelming. Each visa type has its requirements, timelines, and potential pitfalls. Without the proper guidance, it's easy to make costly mistakes and face unexpected denials. Today's conversation will break down the major non immigrant work visas available in 2025, explain who they're for, and give you clear, practical tips for building a strong application. Whether you're starting a business, taking on a new role, or investing in the United States, this session will help you better understand your options and next steps. We are honored to be joined by Attorney Mitchell, a seasoned immigration attorney, a partner at Bucket Sage Immigration Law in New York. Attorney Michelle Mitchell holds a JD from Cornell Law School and a BA from the University of Pennsylvania. She has litigated before state and federal courts nationwide, including the U.S. Supreme Court, and has experience spanning immigration, criminal, commercial, and constitutional law. Attorney Mitchell is admitted to practice in New York and federal courts and is an active member of the American Immigration Lawyers Association and the New York City Bar Association. Known for her sharp legal strategy and client centered approach, she brings deep knowledge and practical insights to every case. Welcome, Attorney Mitchell, and thank you for joining us today.
Thank you very much, Nikita. It's a pleasure to be here today and to speak to everyone. Um, we are going to be discussing today U.S. work visas for investors, entrepreneurs, professionals, um, and focusing on non-immigrant work visas. So these are not visas that for green cards and permanent residents, but they can have pathways for a green card and permanent residence, and I'll be discussing that as well. So we're going to start with a presentation. Do you know if it's up on their screens now, Nikita?
Not yet. So
Okay.
before we dive in,
Mhm.
a quick but important reminder, immigrationquestion.com is a two-in-one platform that connects users with licensed immigration attorneys. We are not a law firm and we are not affiliated with AILA or USCIS. All legal services are provided independently by lawyers in our network. So let's dive into today's session. You have the floor, Attorney Mitchell.
Okay, great. All right. So, yep, as you can see up on your screens, we're going to be doing a presentation, non-immigrant visa options for investors as well as professionals, entrepreneurs who are, potentially looking to start a company in the U.S. or to transfer into an existing company in the U.S. So, can we go to the next slide, please? Okay, so the first slide we're going to discuss is just a brief overview of the four visa categories that I'm going to be discussing today. The first category is the E2 visa for treaty investors. Now, this is what I would call more of an investor visa for folks who are looking to invest into a business in the US, or they are working as managerial or essential employees for an investor who has invested into the US. Now, the E2 visa is only available for treaty country nationals. So there are a certain number of countries You can, look these up online, that the US has a treaty with that allows for these sort of investor visas. And as I said, it's both for investors as well as their employees who have either managerial or essential skills. Now, the investor, who has to be from the treaty country, must own at least 50% of the business. So that foreign national can own 50%. Maybe the other 50% is owned by a US citizen or a citizen from another country. And any employees that they bring over have to also be from that investor's home country. The duration of time, it's an indefinite duration in the sense that you can keep renewing the visa. Now, it is for each country, they have different periods of time that you're allowed to have the initial visa for before you have to then renew. So some countries are 2 years, some countries are 3 years, some countries are 5 years, and then you can renew. Another good thing about this visa is that your spouse can work on the visa as well. So if you get an E2 visa, your spouse and your children under 21 can come over to the U.S. on this visa as an E2 dependent, and your spouse can, work. They don't have to work for the company that you're investing in. They have work permits that they can work elsewhere. So that's the E2 visa. The next visa that we're going to be discussing is the L1 visa, which is the intra-company transferee. Now, this visa is mainly used for folks that are working abroad, usually at a multinational company that has offices abroad and offices in the US. And the company wants to transfer them from the foreign office to the United States office. So there has to be a nexus between the U.S. company and the foreign company. So that nexus they can be an affiliate, a parent subsidiary relationship, a branch, but there has to be a legal nexus. This visa is for either executives, managers, or folks who have specialized knowledge. So if you supervise and manage others in the company, the foreign company, if you're an executive, or if you have a specific, very specialized knowledge that you need to bring with you from the foreign company to the US, this would be that type of visa. The duration is, you can get it if you're specialized knowledge for 5 years, 7 years if you are in executive or managerial. Now, again, each country is different how long they'll allow the initial period. Some are 3 years, some are 5 years, but you can then extend the visa, and also your spouse can work on this visa if they get what's called an L2 dependent visa. The next visa category we're going to discuss is the O1 visa. This is an extraordinary ability visa for those folks in the arts, the sciences, and business, also athletics, who have really excelled in their field of expertise. This visa, again, is you can keep renewing it. You typically get it for 3 years, and then you can keep renewing it in 3-year increments. Unfortunately for this visa, your spouse cannot work. And then the last visa we're going to be discussing today is the H-1B visa. This is a specialty occupation visa. It's very, very common for professional workers who, have at least a bachelor's degree. You get it for 3 years, and you can extend it an additional 3 years for a total of 6 years. Your spouse cannot work on this visa in very specialized circumstances, which are outside of the scope of what we're going to discuss today. And this visa is lottery based. So because it's so popular, you have to first enter into the lottery. And then if you're chosen, then you can apply for the visa. If you have a master's degree, you're going to be placed in a separate lottery than for those who just have a bachelor's degree. So for those with a master's degree, you have a better chance of getting selected for the lottery. All right. Can we go to the next slide, please? Okay, so now let's talk a little bit more in depth about the E2, which is the Treaty Investor Visa, and more about what the requirements are for this visa. So as I said, you have to be a national of the treaty country to get this visa. You must own 50% of the business. Dual nationality is allowed. So let's say you're a national of, one country that's, in the treaty and another country that's not. You are still allowed to apply for the visa. You have to put in terms of investment, what USCIS determines to be a substantial investment in the United States based on what they call the proportionality test. And so this really depends upon the type of business, but you need to be able to invest enough money for the officers to be able to see, okay, this is enough money for this type of business to get off the ground and running. So if the type of business is something like, more remote work where you don't necessarily need a lot of infrastructure, office space, equipment, usually more tech-based, businesses and startups, you might need less of an investment than if you were to, open, let's say, like a franchise or a brick and mortar store or something that, you're going to have a lot of equipment, a lot of overhead. We typically see investments of, I would say, at least $100,000 US dollars for this to go through as a substantial investment. The enterprise has to be a real and operating commercial enterprise. So you've got to show that the business, you've set up the business, you've started operations, you've invested the money, and it's a real thing. You have to be able to show evidence of this. Another requirement is that the investment has to be more than marginal, or more than solely for the living of just yourself and your immediate family. What that means is you have to be able to show that and this is usually done through a business plan, that your enterprise, your investment is going to, through, your business plan, hopefully be able to hire workers, and really have earnings that aren't just for you and, your spouse and your kids, but that you're really going to be providing a living over time for others, like other U.S. workers, for example. The applicant has to be in a position to develop and direct the enterprise. So this means that it's not just a passive investment, that the applicant is really involved in the company, involved in operations, involved in directing the enterprise. Now, it doesn't mean that they have to be on the ground, day to day at the location, but they have to have, managerial oversight of the enterprise. Okay, and then if the applicant is an employee, so they're not the investor, right? They need to have a managerial position or have essential skills for the operations in the US. And this employee has to be from the same country as the investor. And finally, this is not a dual intent visa. What that means is there are single intent visas and dual intent visas. This is a single intent, meaning you cannot have the intent to immigrate permanently in the US on this visa type. So it is not a pathway for you to then get a green card. You can, while you're on your E2 visa, apply for, let's say, an employment-based green card like an EB1, extraordinary ability green card, or an EB2 national interest waiver green card. But the issue is that, let's say you're on your E2 visa, you're applying for the green card, and you want to leave the US, for vacation or whatever, go back to your home country, come back. You might have issues re-entering the US on your E2 visa because you are in the process then of applying for permanent residency. Whereas an E2 visa, your intent is not that you want to have permanent residency. Your intent is, that you're going to ultimately go back to your home country. So that's something to consider with this type of visa. And many times we have clients who are on an E2 investor visa that want to then, apply for the green card, like the extraordinary ability green card. And we usually try to switch them over to, for example, a dual intent visa like an O visa or an H-1B visa before they apply for their green card, so that they won't have any sort of issues re-entering the US, or let's say if they, it doesn't get the green card doesn't get approved, they won't have any issues being able to renew, their visa. So that's the E2 visa. Next slide, please. Okay, now we're going to discuss the L1 intracompany transferee visa in more detail. So with this type of visa, you have to have worked at the foreign company for at least 1 year in the preceding 3 years before you can transfer into the US. Also, the foreign company must be in existence for at least 1 year before entering the US. The US company must be operational for more than 1 year, or there is something called a new office exception. But this new office exception, so let's say you have a foreign company and you want to start a new office in the US and you want to transfer your workers, or you yourself want to transfer, you've got to be able to put together a business plan that shows what you're going to be doing in the US, how many workers you're going to be hiring, what your projected financials are. USCIS wants to see that this is actually going to be a real operation in the US. They also want to see that the foreign company is still going to be running. There's still going to be, you can't transfer all your employees over from the foreign company to the US company. You've got to, still keep the foreign company running, and there's got to be people there on the ground that are, running the company. The relationship between the two companies. So you can't, have a foreign company and then just start a US company with no relation to the foreign company. So that they have to either have a parent subsidiary relationship, an affiliate relationship, or a branch. The person, the beneficiary who's going to be transferring into the US company, they have to either be have been an executive of the foreign country, and they're going to be an executive in the US, have managerial experience back in the foreign company and going to be a manager in the US, or have some type of specialized knowledge that they can have only have gotten with that particular company, and they're going to be then transferring that knowledge over to the US company. Now, this visa, unlike the E2 visa, is a dual intent visa. So you are able to convert to a green card, and this is for managers and executives only, and that is under the EB1C category. Okay, next slide, please. Okay, now we're going to be discussing the O1 visa, which is the Extraordinary Ability Visa. And this visa is for, folks that have extraordinary abilities in their field, whatever that might be. That could be, in the arts. We've worked with, culinary experts, chefs, artists, filmmakers, musicians, producers, and you name it. And then also more in the business field. So any type of business field, whether it's, CEOs or entrepreneurs. It's very often used in academia with professors and people who are involved in research, as well as athletics and really talented athletes. This type of visa, it's you cannot self-sponsor yourself, so you have to have a U.S. company that sponsors you. Now, this could be, a company, that you're working for, that you're an employee, or, we see in many circumstances, for example, entrepreneurs that want to start their own company in the US, they can form that company themselves and they can own 100% of the company, and that company can sponsor them. The only caveat with that is that they must have a board of directors or other members, managers controlling their employment. So that means, setting up an operating agreement or bylaws for the company that explicitly state that. Um, you must meet three criteria to get the O visa out of eight. So I'll go through each one. The first one is nationally or international prizes or awards in the field. So this, typically means that, you've won an award in your field and it's, anybody in your country or internationally could have applied for the award. So it's not like, you won an award for like within your company or within your school. It's got to be, an international or nationally recognized award. The second criteria, membership in associations that require outstanding achievements of their members. So this is, you know, um, basically professional, memberships where not just anybody can join or anybody can pay a fee, but you've really been invited because of your outstanding achievements in your field. The third is published materials about you in professional or major trade publications, and this can even be published materials about you in online digital media as well, as long as that digital media has enough circulation numbers that it could be considered major media by USCIS. The fourth is participation as part of a panel or the judge of the work of others. So this can be like if you're, peer reviewing an article, if you're on a panel, let's say for, judging like a business startup competition, or even in some instances, really mentoring and evaluating and training, employees in your own field. The fifth one is if you have an original scientific, scholarly, artistic, athletic, or business related contribution of major significance in the field. This one is very difficult because you have to really show that that your contribution has been major and significant in the field as a whole, and people all over your country or all over the world are implementing it. The sixth one is authorship of scholarly articles in your field. They can be published in, major trade publications like business journals or medical journals or other, major media where you are authoring the article versus the published materials is material about you. The seventh one is having a critical or essential role for organizations that have a distinguished reputation. So if you really play a critical role for the company that you worked for, and that company has a distinguished reputation in the field. And then finally, if you command a high salary or other high remuneration for your services compared to others in your field. So this can be a salary, or it can be, if you're owner of a company, how much your, shares are valued at, as compared to, looking at other people in your field, and what their average salary is. So that's the O visa, and you have to meet 3 of those 8. Uh, Last slide, please. Okay, the last visa we're going to be talking about is the H-1B. I know we don't have much time left, so I'm going to go quickly. So the H-1B, it's a very common visa. You have to have a job that typically requires a bachelor's degree to get this visa. And you either have to have a bachelor's degree or at least 12 years of experience in that field. The U.S. company has to sponsor you. It's not self-sponsored. Can be newly formed. And it's the same like the O visa, where if you own, the company, then you would need to get a board of directors. Um, the position, that you must get a prevailing wage for the location and type of employment. So where the other visas, like an O visa, your salary doesn't have to be any particular set salary. It can even be commission based. But for the H-1B, you have to be paid the prevailing wage. And then lastly, the employer must post a notice of labor condition application and maintain public access to the file with specific documentation. And again, this visa is lottery based. For bachelor's degree holders, we're seeing roughly about 30% of the applicants, being selected for the lottery. For the master's, if you have a master's degree, it's much, much higher. And that is it. I know we're sort of running out of time, so I don't know, Nikita, if we're going to take any questions or how you'd like to handle it.
Thank you so much, Tani Mitchell.
Mhm.
So we will proceed. This session so far has been insightful, and I'm sure our audience agrees. To everyone joining us from Facebook, YouTube, and LinkedIn, thank you for being here. Whether you're a legal professional, community advocate, or someone just looking to understand this better, we're grateful to have you. And if this is your first time joining us, welcome. We are immigrationquestion.com, a two-in-one platform built with lead and case management features to help simplify the immigration process. Though we are not affiliated with AILA, we are we are trusted by many AILA attorneys who use our platform. Also, with immigrationquestion.com, you can ask your immigration for free in any language and get connected with a licensed immigration attorney for legal guidance. And yes, just like many of our users, you may receive a free confidential initial consultation. Just visit www.immigrationquestion.com to learn more. And it gets better. We have just launched our new mobile app designed to make access even easier, whether you're a user or an attorney. Attorney Mitchell, with your extensive experience in immigration law, how would you describe the impact of immigrationquestion.com and how it's having on the immigrant community and on immigration attorneys like yourself?
Yeah, no, I think it's a wonderful resource for folks, all over the world to be able to, get, access to, real attorneys who are providing, information that, versus just, for example, on a blog or on Reddit where you really don't know, the person, and if they're providing you accurate information. So I think, it's a wonderful tool for folks to, as they're starting to think about, coming to the US and what type of, you know, things that they're going to need or what type of visa they might need. yeah, it's wonderful.
Thank you for that. We never get tired of hearing this. Uh, if you're just joining us, it has been an incredible session with attorney Michelle Mitchell on today's topic, Pathways to Employment in the United States, Understanding Non-Immigrant Work Visas for Investors, Entrepreneurs, and Professionals. Now we're moving into our live Q&A session. So if you've got any questions for Attorney Mitchell, now's your moment. Drop your questions in the chat or call us live at 516 703 3483. So we've got our first question from Damien Thomas. My EAD C9 was outside of normal processing time. I did a case inquiry yesterday. How soon before USCIS replies to the inquiry will be a decision on my case, or they going to reply soon? Still looking into it.
Yeah, so USCIS has 30 days to review and get back to you with your inquiry. So typically, they do take, sometimes they're faster, but sometimes they'll take the full 30 days to get back to you. And then unfortunately, sometimes they'll say, we're still, reviewing, looking into it, even though it is outside normal processing times. So unfortunately, there's not much that can be done other than to keep, reaching out to them. If it becomes, such a huge delay, there is, you can go into federal court, for example, through a writ of mandamus and, request that the government act. But this, is a costly endeavor. You'd have to hire an attorney who's, licensed to litigate in federal court that can do this for you on your behalf. So, there's not, again, much that you can do, but other than to keep, inquiring about the case, and then if it gets to be so long, then really you should be seeking to speak with an immigration attorney who might be able to go into court.
Thank you, Attorney Mitchell. We have our next question. Please help me to get study in United States. I am interested to go there for good education and most comfortable life.
So with student visas, they pause them for a period of time. Now they're back up and running. So that the student visa is the F visa. So the process that you have to take is you really need to start looking into schools that you want to come to in the U.S. And each school has what they call a DSO, and that person really helps international students, apply for the student visa to be able to study in the U.S. So, your first step really is to start, researching and looking into what schools you're interested in applying to, and then reaching out to that school's DSO for more information on how you apply. And then, once accepted, then they'll provide the paperwork that you'll need to then go to, your embassy abroad to get the student visa stamped on your passport.
Okay, so we have our next question. My startup just raised $1 million in seed funding, but I don't have patents or awards. Will that be enough for an O1A extraordinary ability visa?
It could be. So, awards, for example, are only one of 8 criteria, and many people who are successful with the O visa don't have awards, or their company doesn't have, patents. What USCIS is really focusing on is your personal expertise and experience over the course of your career. So, if you've had leading roles not only for your company that you've got the 1 million in seed funding, but other organizations that you've worked with in the past, and those people can write letters of support for you. That's very helpful. If you've written scholarly articles or have publications about you on the internet, or if you have professional memberships, or if you've done any type of judging on panels, like if you're in the tech, entrepreneur world, if you've done like judging for startup competitions or accelerators, or have memberships in accelerators, all those things help because you have to be able to, get 3 of those 8 criteria. You don't have to get each one.
We have another question from David. I came here on a skilled worker visa, but my job role changed after 6 months. Will this affect my residency status?
I'd have to know more about your situation, um, and what exactly changed with the role, and if you were you on in what visa type. So unfortunately, I can't answer that just with this information.
We have another question from Liam. I'm an Australian software engineer. Should I go for the E3 visa or should I try for H1B lottery?
I mean, you can do both. There's no harm in trying for both. Again, the H-1B lottery, it's more difficult because of we're seeing, like I said, about 30% of people getting selected if they don't have a master's degree or higher. So if you have a higher degree, you have a good chance. Otherwise, you're Australian, so you can, obviously you apply, can satisfy the E3 visa. So either is a good pathway. The H-1B is nice because it's a dual intent. So if you have if you want to ultimately stay in the U.S. permanently and potentially get a green card, that might be the better option. Um, but you could always apply for both.
Okay, we have another one from Rajesh.
Mhm.
I'm from India and got an H1B offer as a project manager. How do I improve its specialty occupation to avoid denial?
Yeah, so you really have to be able to show that the project manager job is such that it requires a bachelor's degree to perform. So we a lot of times do this by showing that, other people hired in the company all have bachelor's degrees, that and other types of jobs similar to this, to your job with similar job duties, also require a bachelor's degree, like going, you could even go on like indeed.com and some of the job, posting networks and see, okay, this is a job for a project manager. It's got similar job duties as mine and they're requiring a bachelor's degree. I would say that that's a really good way to be able to show that, that the particular job and all of, the duties really are a specialty occupation in that they, require at least a bachelor's degree.
Okay, we've got another one. My employer used the old USCIS form for my H1B after the April fee change. Will that delay or kill my application?
So if he used the old form, I'd have to see when and if there was any sort of grace period. But unfortunately, if they use the old application and there's not a period in play, it will be sent back. And then he'll have to refile with the new form. So USCIS will alert you that, and they'll send it back to you and request that you refile.
Okay, I think we have a last question for today from Yuki. Can I come to the United States on a B1 to set up my startup and work remotely from my own company?
So this is very, sort of tricky because when you're coming on a B1 visa, you're not allowed to work on the visa. It's really only for going into meetings and negotiations and trainings. So what many people do is, they're starting to, think about, they want to start their company in the US and that they're going to, do like an O visa or investor visa, right? But in the meantime, they want to start, getting things set up, like meeting with, people to get an office space or meeting with investors. You're allowed to do all these types of things like meetings in order to try and set up your company, but you can't, work in the US and we're actually getting paid an income. So there's that distinction. You have to be very careful about this because let's say you come into the US, and we've seen this with clients where you come in on a B1 visa and you're here for a long time, like you're here for many months, 3 to 6 months. And then they start to wonder, okay, well, were you working during that time or were you just setting up? So it could affect being able to get a work visa in the future. So you have to be very careful. We always say don't spend long periods of time on the B1 in the US setting up your company, or come in and out more. But that would be my recommendation.
Okay. Thank you so much for walking us through all of that, Attorney Mitchell. To our audience, thank you again for joining us. We hope this conversation gave you clarity on the pathways to employment in the United States. Don't forget, at immigrationquestion.com, you can ask your immigration questions for free and get in touch with a licensed attorney who understands your case. You may also be eligible for a free confidential consultation. So head over to www.immigrationquestion.com and sign up today. And if you want to revisit the session or share it with your colleagues, you can catch it on Spotify. Just search Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening conversation with attorney Adriana Gomez on the topic Surviving the In-Person Interview, Preparation and Practice for Marriage-Based Residency. You won't want to miss it. Once again, thank you so much, Attorney Mitchell. We can't wait to have you back.
Thank you very much. Lovely to be here, and good luck to everyone.
Thank you.